Branch 2 is now in session. The Honorable Thomas J. Walsh presiding. Your silence is requested.
Be seated. Okay, I'll call this case then. This is 20 CF 1393. Actually, pardon me, it's 22 CF 363. State of Wisconsin versus Taylor Schabusiness. State appears by District Attorney Lizay. The defendant is appearing via the Zoom from the jail. And in court is the attorney that's representing her on the competency matter, Quinn Jolly. Also appearing is attorney Heather Richmond. We're on the court's calendar today for a review of the competency evaluation that this court ordered. I'm in receipt of the competency evaluation. Let me just check with the parties. Mr. Lizay, has the state received that evaluation?
Yes, we have.
And Mr. Jolly, have you or your client had an opportunity to receive that and review it?
Yes, Your Honor.
Okay. So that report has some specific findings indicating that, according to this evaluator, Ms. Schabusiness is competent to proceed. Mr. Jolly, your client's position?
Your Honor, at this point, my client would be seeking a second examination. The court must appoint one examiner, but can appoint more. After review of the report and the examiner's comments to the court, that the court should remain sensitive in the event of any signs of fluctuations in her overall mental status and behavioral stability. Such changes may signal fluctuation in her capacity. Ms. Schabusiness has been receiving mental health treatment since the 7th grade. She's been psychiatrically hospitalized multiple times. She's been diagnosed with bipolar and psychotic. This may have been one of her better days. However, I'm very surprised at the result of this report.
Okay, so you're asking the court to appoint another evaluator to essentially review what this report was. Is that what you're indicating?
Yes, Your Honor.
Mr. Lizay, does the state take any position on that?
No, we don't have a strong position on this. However, I would know Dr. Collins is highly respected. I think she's the head of that particular unit that does a number of these. So she's very experienced and does a number of these evaluations. We've accepted her reports on countless occasions. I'm not sure that the county or the state should pay for a second evaluation. I know there's another alternative is that the defense is entitled to have an expert evaluate their client at any time under sub 2, sub G of the statute. So I won't take a strong position one way or the other. I just wanted to note that we highly respect Dr. Collins' opinions on these issues.
I guess, Mr. Jolly, maybe you can relate to me, because I'm aware of the fact that funding is available whereby you could select your own evaluator. And you're asking me to appoint someone else when I've already appointed this individual. Have you thought about pursuing that on your own and selecting your own evaluator? Or you're specifically asking me to select another person to...
Correct, Your Honor.
Okay, so I guess here's the thing, counsel. I don't have any problem at all, really, if the defense is looking to get what would amount to a second opinion by someone of their choosing. Where I'm struggling here, and I guess I'm telegraphing this to you, Mr. Jolly, is it sounds like you're looking to the court to say, don't believe the first one you picked, pick somebody else, and I'm not sure I'm there yet. So I guess I'm going to need a little bit, you outlined a little bit about what your position is and why you've got this concern, but I'm not convinced why I'm going to order another public expense to somebody else from perhaps the same facility to do another evaluator. And Mr. Lizet is correct. This individual has done evaluations for the court before, and they've been submitted. I don't see the court ordering another evaluation by someone that I choose. I've already chosen someone, and they've done an evaluation. So I'm not inclined to grant that request. If upon discussion with your client, you want to make a request to have someone of your choosing do it again, as I've indicated, I don't have a problem with that. I'm not going to grant your request to have the court pick another person because, again, we come back and we could just continue this until we get a different answer. I'm not inclined to do that without further evaluation. You want to contest this, you can do that. But certainly the report indicates that this is something that should be monitored throughout, and that if further questions arise, that there should be a reevaluation done. But I'm not going to order somebody else to do another one that this court selects. If you want to request to have an independent evaluation done by someone you select through funding that I know is available, I'll certainly approve that. But that's the decision the court's going to make.
Your Honor, I have talked to my client about getting an independent examination. We are going to pursue that.
You are going to pursue that?
We are.
Okay. Very good. Then that's certainly within the realm of the things that occur at these types of hearings. And I think the next thing to do, counsel, would be for me to set another status conference when we would receive that report. And then at that point in time, the attorneys can decide how they want to proceed, be it with a contested competency hearing or something else. Mr. Lizet, does that sound like a reasonable course of action?
It does, Your Honor, and I just would inquire from the defense whether they know that funding has already been approved, and if they can get someone in short order, if that would just help us with scheduling.
It has not been approved at this point, Your Honor.
Okay. Well, that creates a little bit of concern regarding the timing of the next hearing, of course. At the same time, I guess I would want to know promptly if funding isn't approved, because then we may need to get back together sooner and decide what's the next course of action there. But does 30 days sound a reasonable period of time, Mr. Lizet?
It does to me, as long as Attorney Jolly has discussed this with the defendant. She understands that there's a delay in these proceedings as a result of this decision.
I'm assuming, Mr. Jolly, we've had that conversation.
Yes, Your Honor.
Sound 30 days sound like a reasonable time frame, because you're going to have to get the authorization, the approval for the funding. You're going to have to then get the evaluator lined up, and then get the evaluation done, get a report, and then get us back into court. Does that sound like a reasonable amount of time?
It does, Your Honor.
Your Honor, as far as scheduling, I would ask to be able to be withdrawn from the case, and then I don't need to worry about my calendar and coming back. It appears the defendant is moving forward with Mr. Jolly, and I'm fine with that.
Okay.
So if I could be excused from the case, that would be great.
Sure, and I can do that, Ms. Richmond. I appreciate your position, and as I indicated at the last hearing, I was going to wait till this issue, the competency, was resolved before making further inquiry of Mr. Business on this topic, on the topic of representation, because I consider this still an issue that's contested. I wasn't ready to make inquiry to that effect, but I'm happy to excuse you from any further participation in the case, and you're not obligated to come any further. Okay.
Thank you.
Very good. So I'm looking at a date about 30 days hence. It's a little bit before 30 days, but on May 10 at 3 o'clock, Mr. Jolly, does that work for you?
It does, Your Honor.
On that topic, anything further for the record today, Mr. Lozay?
No, Your Honor.
No, Your Honor.
Okay. Counsel, there was the other topic of the totally unrelated matter, there of the sentencing after revocations on the 2 other felony files. Was counsel intending to proceed on that today? Were you looking to do something else with those? And I guess I'll start with you, Mr. Jolly.
Your Honor, we don't believe we can proceed at this point due to the competency issue. We ask that this follow present case.
That seems to be the best thing to do. I know it was put on. These are supposed to be heard promptly, so we put it on for today. That's really not what this hearing was intended for. It seemed to make sense to wait until that issue was resolved. Frankly, I'm not sure the extent to which I could proceed as long as that was in play. Mr. Lozay, any objection to that?
No, I agree with that.
All right, so I'm going to put those matters on for simply status conferences then at 3 o'clock on the 10th of May, and those will trail along. And depending on what happens at that hearing, we could conceivably proceed at that time or adjourn them further to wait for the results. So, anything else for the record today then, Mr. Lozay?
No, Your Honor, thank you.
Anything else, Mr. Jolly?
No, Your Honor.
Okay, then with that, the matter is concluded for the day. Thank you very much.
Thank you.